No-win, no-fee arrangements proceed on the basis that clients will not be charged fees unless they win the case. For the purpose of these agreements, a settlement in which the client receives a sum of money is defined as a win. While these arrangements may appeal to those who cannot afford to pay upfront legal fees, there are issues that need to be considered before agreeing to such an arrangement. A lawyer may work on a client's case for months, often years. If the ongoing legal fees become high, the client may form the view that the lawyer may have a vested interest in them settling the case, so the lawyer can be paid and avoid the possibility of losing the case. In some instances, accepting an offer may be the best course of action for a client. However, the key issue here is that the client may question whether the advice their lawyer is providing is truly in their best interests or is being influenced by other considerations. All lawyers have an obligation not to commence court proceedings on behalf of a client, unless they believe that the claim has reasonable prospects of success. However, people may think if a lawyer is prepared to take on their case on a no-win, no-fee basis, that they must be almost certain or almost guaranteed to win their case. That is not the case. Experienced lawyers are aware that even cases that appear to be strong at the commencement of the matter can become weaker as the case progresses, due to the evidence presented by the other side. Indeed, even the strongest cases on paper can be significantly undermined by cross-examination at the hearing, and the judge who hears the case may have a completely different view of it than either of the parties involved. Litigation almost always involves a significant amount of risk, and no lawyer can ever guarantee the outcome of litigation. No-win, no-fee cost agreements need to be read carefully. These cost agreements often contain a clause which provides that the client becomes liable to pay the legal fees if they do not follow their lawyer's advice. It may appear trivial at first, but what if your lawyer's advice is to settle? If you don't follow that advice, the legal fees accrued may become payable. In circumstances like this, the client may feel the financial pressure to accept a settlement. Some no-win, no-fee agreements may exclude certain disbursements or other fees from the arrangement, meaning that you will be liable to pay for those fees or expenses regardless of whether you win. For example, additional barrister's fees, court fees, and third-party costs are often excluded from the no-win, no-fee arrangement. In New South Wales, solicitors are permitted to include a clause in a no-win, no-fee cost agreement, enabling them to charge up to 25% more than the total fees incurred. These fees are an additional reward for the lawyers for waiting a period of time to be paid, and for taking the risk that the claim could fail and they will not be paid. If the uplift fee is added to the legal fees to be paid, it will substantially increase the overall amount to be paid by the client. It is important to know that a no-win, no-fee arrangement is not the only alternative payment arrangement available to clients. We offer deferred payment arrangements in certain circumstances. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers led by our founder, Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +6102 8089 3139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.